G'day everyone, and welcome to the fourth episode of Agony Anth, my collaboration with the Charles Darwin University Law Student Society. This video is being made at the very start of November 2020, and in the last couple of weeks, the United States of America has appointed a new judge, Justice Amy Coney Barrett, to the United States Supreme Court. And Australia has appointed two judges, Justice Jackie Gleeson and Justice Simon Stewart, to the High Court of Australia. This has led to our question for this week. How does Australia appoint our High Court judges? Well, the first thing I can tell you is that our process is very different to the process you would have seen in the United States. In the United States, the process of appointing Supreme Court judges is explicitly political. The President appoints the judge, and then the judge must face questioning by a committee of the United States Senate. They can get quizzed on basically anything, from their personal life to their political views, to their legal philosophy. The outcome is usually pretty well preordained when the President's party has the numbers in the Senate, as is the case currently. The whole process is utterly characterised by partisan politics. Unfortunately, it's also fairly undignified, but then again, there's a lot about the United States system that is undignified. In Australia, under Section 72 of the Constitution, High Court judges are appointed by the Governor-General in Council. Those last two words, in Council, are super important. What they mean is that the Governor-General is not entitled to simply choose a new judge themselves. They must do so on the advice of the Prime Minister and the Commonwealth Attorney-General. So, in reality, it's the Prime Minister and the Commonwealth Attorney-General who determine appointments to the High Court. Well, hang on, I hear you say. That actually sounds a lot like the United States process, but with the Prime Minister making the choice instead of the President. At least in the United States, there's a process where the Senate gets to vet the nominee. How is our process better? Well, to answer that, we look to other processes, one of them formal and statutory, and the other one informal but just as powerful. First, the statutory process. Section 6 of the High Court of Australia Act 1979 requires that before advising the Governor-General to make an appointment to the High Court, the Commonwealth Attorney-General must consult with the Attorneys-General of each state. Now, that doesn't give the state Attorneys-General any actual power in relation to the appointment, but it does give them a certain amount of influence. Second, there's an informal but powerful custom where the Attorney-General is expected to consult with the legal community about proposed appointments to the High Court. In practice, this means having discussions with people like the presidents of the state and territory bar associations, the presidents of the law societies, and perhaps even consultation with prominent legal academics. The idea of these two processes, these two consultation processes, is for the Commonwealth to appoint new judges who will be broadly accepted and respected by all of the states, by both sides of politics, and who will be regarded as impartial judges. Now, realistically, it is inevitable that all else being equal, the Prime Minister or Attorney-General is going to prefer a judge who seems to lean in the direction of their political philosophy. However, if they have such a judge in mind and they receive a lot of pushback in the consultation process, the reality is that they probably won't appoint that judge. In fact, you can see how well the process works in Australia by looking at the few times that it didn't work. In 1913, Mr. Albert Bathurst Pettington, a Sydney-based barrister, was appointed to sit on the High Court on the nomination of Attorney-General Billy Hughes, who was later Australia's wartime Prime Minister. Pettington was regarded as something of a radical, and in fact, he was on his way back to Australia from an international conference on eugenics when he was first contacted about potential appointment. Eugenics is the idea that breeding of humans should be controlled in order to stamp out undesirable traits. It was one of Hitler's favourite philosophies. Mr. Pettington received a telegram asking whether his personal views were sympathetic to increasing or decreasing Commonwealth power. And when he said increasing, he was offered a spot on the High Court. His appointment caused an outcry among legal circles who had not been consulted in relation to that appointment. It was considered that he lacked the significant experience and level of broad respect required for a High Court judge. Under pressure, he resigned just 1 month after his appointment. More recently, and at a state level, Justice Tim Carmody was appointed as the Chief Justice in Queensland in July 2014. He had spent 5 years as a judge in the Family Court and 2 years as a judge in the District Court and as the Chief Magistrate in Queensland. He was not regarded as having had any substantial experience in the Supreme Court at all. He was close to the Attorney General Jared Bligh, who nominated him despite the broad lack of support for the appointment among the legal profession. Once the appointment was made, the President of the Bar Association in Queensland resigned. Many prominent legal figures in Queensland came out against the appointment, and in fact, Chief Justice Carmody was not sworn in the usual solemn ceremony in the Banco Court, but in a small private room in Government House. He lasted for a year under all sorts of pressure and then resigned. So in Australia, it's definitely fair to say that the Prime Minister has substantial power to influence appointments to the High Court. But the Prime Minister's hand is not free. There is a long process of consultation, and there must be at least a minimum level of consensus in favour of the new appointment. There's one other feature of judicial appointments in Australia that sets it apart from those in the United States. An appointment to the Supreme Court in the United States is an appointment for life, whereas an appointment to the High Court is an appointment to age 70. What this means is that in Australia it's predictable when a High Court judge is likely to retire, whereas in the United States it's usually not predictable when a Supreme Court judge is likely to die. The fact that judicial retirements in Australia can be predicted a long way out means that there is plenty of time to have a proper consultation process, unlike the undignified and rushed process that we've seen by American Republicans seeking to shove the appointment of Justice Barrett through the system prior to the 2020 presidential election. The result of all this is that High Court judges tend to be experienced, respected, and broadly supported. The Prime Minister has substantial power, but in reality that power is subject to influence by the State Attorneys General and by broader consultation within the community and the legal profession. If you have a question for Agony Anth, by all means send it on in. We've had a great few questions sent to us and waiting to be answered already, and hopefully you're having as much fun with this as I am. See you soon.